Thank you for coming by. This is an American project. Please be sure to like the video and consider subscribing. Well, I'm going to take a look at the court documents from the Fani Willis case to see what the judge has to say. All right, now in the opening, it says what the order is about and who the defendants are that complaining about the prosecutor. And it says what an actual conflict of interest is. Our highest courts consistently remind us that prosecutors are held to a unique and exacting professional standard in light of their public responsibility and their power. Every newly minted prosecutor should be instilled with the notion that she seeks justice over convictions and that she may strike hard blows but never foul ones. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for one side and must make decisions in public's interest, not their own personal or political interest. Okay, now it goes on to say, determination of whether a prosecutor is laboring under a conflict of interest is a fact-driven one. In this case, Wade's manner of payment is not actionable on its own. Whenever a private attorney like Wade is paid by the billable hour, a motive exists to extend or prolong the assignment. This, however, is a tension that the legal profession has long accepted. It is also the type of speculative status violation that our courts have regularly denied as insufficient grounds for disqualification absent solid proof of some other conduct. Finding wrongdoing cannot be imputed to an attorney based on marital status alone. Thus, the Special Assistant District Attorney's oath of office in combination with the supervision theoretically provided by a neutral and detached district attorney should generally be sufficient to dispel the appearance of that improper incentive. Nor would a romantic relationship between prosecutors standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as their relationship persisted. But in combination, as is alleged here by the defendants, an argument arises of financial enrichment and improper motivations, which inevitably and unsurprisingly invites a motion such as this. As to the financial allegations, the court makes the following factual findings. On November 1st, 2021, the district attorney hired Nathan Wade to serve as a special assistant district attorney and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade, extending an offer to former Governor Roy Barnes, who declined. The contract allowed a $250 hourly rate, a relatively low amount by Metro Atlanta standards for an attorney with Wade's years of service, and contained a ceiling on a maximum number of hours permitted. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicates that Wade ever received permission to exceed these monthly hourly caps. His contract was renewed on November 15, 2022, and again on June 12, 2023. Between October 2022 and May 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. The first included an extended trip in October of 2022 to Miami and Aruba and a cruise. Wade initially covered expenses for the October 2022 trip, totaling approximately $5,223. In December of 2022, the two flew to Miami for another cruise for which the district attorney paid $1,394 for plane tickets. While Wade purchased passage for the cruise along with the other vacation-related expenses totaling approximately $3,684. In March of 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of approximately $3,000. In May of 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides in the amount of around $28.29. In addition, the two described taking a number of day-long road trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They also admitted to dining out on multiple occasions and taking turns covering the bill, with seemingly full access to Wade's primary credit card statements. The defendants did not produce evidence of any further documentable expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash. And if not reimbursed, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him money for both cruises. She further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Napa Valley excursions. Finally, while Wade could have bought meals in 2020, which totaled more than $100, she would also regularly pay for his meals. Such a reimbursement practice may be unusual, and a lack of any documentary corroboration understandably concerning. Yet the testimony withstood direct contradiction, was corroborated by other evidence. For example, her payment of airfare for 2 of the 2022 Miami trip, and was not so incredible as to be inherently unbelievable. However, as the district attorney herself acknowledged, no ledger exists, other than a best guesstimate. There is no way to be certain that expenses were split completely evenly, and the district attorney may well have received a net benefit of several $100s. Despite this, after considering all the surrounding circumstances, the court finds that evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was, or currently remains, greatly and pecuniarily interested in this prosecution. In addition, and much more important, the court finds, based largely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute this case. While a general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in any great need, as she testified that her salary exceeds $200,000 per year without any indication of excessive expenses or debts. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. While prejudice is not a required element for disqualification, it is relevant to considerations of due process in the defendant's requested remedy of complete dismissal. Defendants argue that the financial arrangement created an incentive to prolong the case, but in fact, there is no indication the district attorney is interested in delaying anything. Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested that the trial begin less than 6 months after indictment. Soon thereafter, the state opposed severance of the objecting defendants who did not demand their statutory right to a speedy trial. The state argued that it only wanted to try the case once, assuming that such a trial would have been affirmed after any necessary post-conviction appeals. The state amended its proposed timeline in November of 2023 to request that the trial commence less than 1 year after the return of the indictment. And even before indictment, the district attorney approved the grand jury presentment that included fewer defendants than the special purpose grand jury recommended. See the order entering special purpose grand jury's final report and court records. In sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of this prosecution or engaging in excessive litigation. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on a case, the defendant's claims of an actual conflict must be denied. This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly, and it is the trial court's duty to confine itself to the relevant issues in applicable law properly brought before it. Other forms or sources of authority such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County may offer feedback on any unanswered questions that linger. But those are not the issues determinative to the defendant's motions alleging an actual conflict. All right. Appearance of impropriety. I will put this on part 2 and then continue from there. There you have the introduction. Thank you for coming by. Please be sure to like and subscribe. I really appreciate it, and have a great day. God bless.